welcome to the Minimum Competence episode for Friday, July 19th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover the Supreme Court's dismissal of 5 major cases from the Fifth Circuit, the espionage conviction of U.S. journalist Evan Gershkovich in Russia, the blocking of Biden's student debt relief plan, and the career moves of 2 former Tesla lawyers. Let's remember, we made it. It's Friday, and read today's legal news. On July 11th, 1911, Pennsylvania enacted the first movie censorship laws in the United States, marking a significant moment in legal and cultural history. These laws empowered a state board to review and censor films, aiming to protect the public from what were considered immoral or indecent content. This move sparked a wave of similar legislation across the country as other states quickly followed Pennsylvania's lead. The push for film censorship reflected broader societal concerns about the influence of motion pictures on public morals, especially on the youth. The legal landscape for film censorship was further solidified in 1915 when the U.S. Supreme Court upheld the constitutionality of these laws in the case of Mutual Film Corporation v. Industrial Commission of Ohio. The court ruled that movies were a form of business, not art, and therefore were not entitled to First Amendment protections. This decision effectively endorsed the state's rights to regulate the burgeoning film industry, leading to widespread and varied censorship practices. It wasn't until 1952, with the case of Joseph Burstein, Inc. v. Wilson, that the Supreme Court reversed this stance, recognizing films as a form of expression protected under the First Amendment. This pivotal shift underscored the evolving understanding of free speech and the role of movies in American culture. Pennsylvania's early censorship laws thus set the stage for decades-long debates over the balance between regulation and freedom of expression in the arts. Over the past 2 terms, the U.S. Supreme Court has dismissed 5 significant cases from the conservative-leaning 5th U.S. Circuit Court of Appeals on the grounds of lacking legal standing. These cases involved controversial issues like abortion rights, online free speech, federal student loans, immigration, and Native American child welfare. By overturning these rulings, the Supreme Court emphasized the necessity for plaintiffs to demonstrate concrete and non-speculative injury to sustain their cases. This approach aims to reduce the number of politically charged lawsuits, often filed in states within the Fifth Circuit due to its conservative reputation. Legal experts note that this trend marks a push for stricter judicial gatekeeping. The Supreme Court's 6-3 conservative majority has reinforced limits on standing, even affecting conservative plaintiffs in Republican-led states. This shift has been evident in cases such as Texas and Louisiana's challenges to Biden's immigration policies and anti-abortion groups' attempts to restrict access to mifepristone. Notably, some decisions were unanimous, while others saw sharp divisions among the justices. The doctrine of legal standing prevents courts from resolving policy disputes better suited for legislative arenas. Historically, liberals tested the boundaries on standing, but recent rulings show a change in this dynamic. The Supreme Court's actions could limit state attorneys general from frequently suing over opposing presidential policies, altering the landscape of American judicial proceedings. On July 19th, 2024, a Russian court sentenced U.S. journalist Evan Gershkovich to 16 years in a maximum security penal colony on charges of espionage, a verdict his employer, the Wall Street Journal, condemned as a disgraceful sham conviction. Gershkovich, 32, was accused of attempting to gather sensitive information about a tank factory in Yekaterinburg and became the first U.S. journalist charged with spying in Russia since the Cold War. His arrest in March of 2023 prompted many Western journalists to leave Moscow. The court, citing state secrecy, held the trial behind closed doors, fueling speculation about a potential U.S.-Russia prisoner exchange. During the hearing, Gershkovich, who maintained his innocence, stood in a glass cage and listened to the judge's rapid verdict. The judge ruled that the 16 months Gershkovich had already spent in detention would count towards his sentence. The Wall Street Journal and Gershkovich's colleagues expressed outrage and pledged to continue efforts for his release, emphasizing that journalism is not a crime. Russian prosecutors alleged that Gershkovich was gathering secret information for the CIA about a company manufacturing tanks for Russia's war in Ukraine. The factory in question has been sanctioned by the West. The rapid conclusion of the trial suggests a potential prisoner exchange could be on the horizon, though the Kremlin has not commented on this possibility. Gershkovich's case has drawn attention to the risks faced by journalists in Russia, with his sentencing seen as a warning to Western reporters. Despite his imprisonment, Gershkovich has remained resilient, engaging with friends through letters and reading Russian literature. This conviction highlights the ongoing tension between Russia and the West and the precarious position of foreign journalists in Russia. Yesterday, July 18th, the 8th U.S. Circuit Court of Appeals blocked President Joe Biden's new student debt relief plan, halting its implementation. This decision came after 7 Republican-led states requested a hold on the U.S. Department of Education's Saving on a Valuable Education Plan, or SAVE plan, which aimed to reduce monthly payments for millions of borrowers. The ruling followed a previous decision by U.S. District Judge John Ross that partially blocked the plan by preventing further loan forgiveness. Missouri Attorney General Andrew Bailey, who led the effort against the SAVE plan, praised the ruling as a victory for Americans who believe in self-reliance. He criticized the plan, arguing it would burden taxpayers with significant debt. An Education Department spokesperson indicated they were assessing the ruling and would communicate with affected borrowers while defending the plan. The SAVE plan, announced by Biden in 2022, was part of a broader $430 billion initiative to cancel up to $20,000 in debt for eligible Americans, but this broader program was blocked by the Supreme Court in June of 2023. The SAVE plan, which partially took effect on July 1st, promised more favorable repayment terms and aimed to benefit over 20 million borrowers, with 8 million already enrolled. Despite already granting $5.5 billion in relief to 414,000 borrowers, the plan's estimated cost of $156 billion over 10 years is disputed by Republican state attorneys general, who argue the actual cost is closer to $475 billion. The legal battle over the SAVE plan continues, with parts of it also being contested in other courts. Two former Tesla Inc. lawyers have recently secured prominent legal roles at new companies. David Meisler, previously an associate general counsel at Tesla, has been appointed general counsel and corporate secretary for Bus Patrol America, LLC. Meisler, who joined Tesla from the U.S. Securities and Exchange Commission, announced his departure from Tesla to pursue new challenges. Emily Locke, Tesla's former chief intellectual property counsel, has been named general counsel for Cohu Inc., a semiconductor equipment manufacturer. Locke transitioned to Cohu as an assistant general counsel in late 2023. These moves are part of a broader trend of former Tesla lawyers landing significant positions at other firms, from startups to established enterprises. Tesla has experienced considerable turnover, with CEO Elon Musk known for his demanding management style. Recently, Tesla sought shareholder approval for Musk's $56 billion pay package and experienced high-profile executive departures amid a workforce reduction of over 10%. Despite this churn, Tesla continues to bolster its legal team, actively recruiting for legal and government affairs roles, if you're into that kind of thing. With that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, note, we are continuing our stated aim to start closing out the week of shows with a musical piece to feature. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme is by Frédéric Chopin. This week, we delve into the world of the Romantic era music with a focus on one of the most beloved composers of the period, Frédéric Chopin, and his exquisite Nocturne No. 2 in E-flat major, Opus 9, No. 2. Born in 1810 in Poland, Chopin is celebrated for his profound contributions to piano music, blending lyrical beauty with technical brilliance. His Nocturnes, a series of short piano pieces, are among his most admired works, characterized by their expressive melodies and delicate phrasing. Nocturne No. 2 stands out for its serene and lyrical qualities, encapsulating the essence of Chopin's style. Written from 1830 to 1832, this piece demonstrates his ability to evoke deep emotion through subtle harmonic shifts and intricate ornamentation. This piece begins with a gentle, flowing melody that is gracefully embellished, creating a dreamlike atmosphere. The central section introduces a more dramatic contrast, yet it returns to the initial theme, now even more richly adorned, before concluding with a tranquil coda. Chopin's nocturnes were heavily influenced by the work of Irish composer John Field, who pioneered the form. However, Chopin expanded upon Field's ideas, infusing them with his unique poetic sensibility and pianistic innovation. Nocturne No. 2 is a prime example of this, showcasing Chopin's mastery of the piano and his profound understanding of musical expression. As this week's closing theme, Nocturne No. 2 invites listeners to immerse themselves in its serene beauty and reflective mood, offering a perfect end to any musical exploration. This piece not only highlights Chopin's genius, but also serves as a testament to the enduring power of romantic music to move and inspire. Without further ado, enjoy the peaceful elegance of Chopin's Nocturne No. 2, a timeless gem in the piano repertoire. Enjoy.